fair to say that of the justices on the court at that time, Black and Frankfurter are the ones that have received the most attention. Douglas was a very influential and interesting jurist, but I don't think that he made a point of trying to explain his jurisprudence the way that Black did. And so I thought that it would make the most sense to look at both Frankfurter and Black because of their reputation, because they were also of interest to me, but also it was I decided to look at those three because Black and Frankfurter, as I argue in my book, represented certain regional traditions in American politics, which I argue was reflected in their particular constitutional jurisprudence. You had the Southerner Black, you had the Northeastern liberal Frankfurter, and they were, as I argue in my book, they were steeped in the political culture of their different regions. You had Black, who was very much influenced by populism at the turn of the century. Then you had Frankfurter, who was very much involved and therefore influenced by the progressivism of the Northeast. So I thought that it was particularly useful it was a useful device to look at Black as being emblematic of a populist kind of jurisprudence, and Frankfurter being emblematic of a kind of progressive jurisprudence, and then use that to try to figure out where Jackson fit in. And so what I concluded was that Jackson was, I think, a transitional figure. That is, that he harked back to the great common law attorneys of the 19th century, and was actually, I think, one of the last great common law attorneys on the Supreme Court. Again, which led to a complicated jurisprudence, one steeped in the facts of individual cases, which led to pragmatic decisions which drive academics crazy. But I think on the whole, what you end up with is a much sounder approach to constitutional issues, where you're very averse, skeptical of the kind of rationalistic approaches taken by his colleagues, Black and Frankfurter.